Welcome to the Business Law Section lunch at the CLA annual meeting. Thank you for joining us and celebrating our Lifetime Achievement Award recipient, Mark Moore, and we look forward to learning more from the program on crypto assets and technology with Eric and Damier. My name is Soyeon Choi, and I had the privilege of serving as a BLS chair this year. It is an honor to convene with you all here today. As we will always be reminded, last year was challenging in nearly all aspects. As a country, as the world took necessary precautions to maintain safety and welfare, we were left to rely on our own judgments. Guidance was often in short supply in our new uncharted territory. However, we found a way forward. We found a way forward through our leadership, as represented by you here in attendance today. Whether you are staff, advisor, part of our support system, a current member, a future member, you contributed to the BLS community, and for that, we are indebted to you. Your judgment and leadership filled the void when business as usual was thrown out the window. Thanks to you, BLS was able to continue from its establishment in 1977 under the State Bar of California, and in 2018 as part of the California Lawyers Association. Our constituency is comprised of approximately 7,000 attorneys, judges, professors, and other professionals. We support 14 standing committees and the Business Law News editorial board. Our standing committees really drive events, publish articles and books, draft proposed California legislation, prepare comment letters with various agencies, provide programs on cutting-edge issues, and host regular meetings for members to share resources and exchange practice notes. Our standing committees drive our events, publish articles and books, draft proposed California legislation, prepare comment letters with various agencies, provide programs on cutting-edge issues, and host regular meetings for members to share resources and exchange practice notes. This year, our standing committees provided content for CLA's Navigating COVID-19 series, which won the National Conference of Bar Foundation's 2020 LexisNexis Partnership Award. We also submitted affirmative legislative proposals on clarifying governance issues during a state of emergency. The BLS Sustainability Working Group was created this year to investigate ways in which our practitioners have been tasked with implementing changes embraced in the business sector. The BLS Sustainability Working Group was created this year to investigate ways in which practitioners have been tasked with implementing change embraced in the business sector. Our members were also instrumental in the creation of a legal specialization in privacy law, the most recent proposal after many years, and the first since CLA has been established. BLS articles placed first and had 3 among the top 10 most visited CLA online articles. These articles were those that drew the most traffic of all CLA e-bulletins as measured through Google search results. BLS articles placed first and had 3 among the top 10 most visited CLA articles. These articles were those that drew the most traffic of all CLA e-bulletins as measured through Google search results. And we held a virtual symposium on insurance law and regulation. And we hosted our own breakout session during CLA's Legislative Day. Of course, we continued our collaboration with the California State Bar and CLA sections, including the litigation section, antitrust, intellectual property, international law, privacy, and tax. We also co-hosted events with local and affinity bar associations, including the Los Angeles Bar Association, the California Latino Judges Association, the California Minority Counsel Program, the Asian Pacific American Bar Association, Bailiff, and LGBTQI Bar Association, Black Women Lawyers, and 13 statewide Latino and Hispanic Bar Associations. Also with the International Association of Privacy Professionals. We provided input on the California Tax and Budget Research Project for Tax on Services, and we are very pleased to continue our sponsorship of the 9th Judicial Circuit Historical Society. We were also very busy collaborating with students. BLS established a publishing partnership with the Santa Clara University School of Law's Privacy Law Initiative. We were also busy connecting with students. BLS established a publishing partnership with the Santa Clara University School of Law's Privacy Law Initiative. By establishing this partnership, BLS provides a platform for students to satisfy one of several requirements to graduate with a privacy law certificate. Our BLS Roadshow continued its many visits during the academic year, and we worked with Our BLS Roadshow continued its many visits during the academic year, and we worked with the UC Davis School of Law, the Santa Clara University School of Law, Women in Law, and California State University at Fullerton. All of this work was built upon the foundations set by our previous BLS chairs and our standing committee leadership. I was fortunate enough to follow the steps. This work was built upon the foundations set by all previous BLS chairs and standing committee leadership. I was very fortunate to follow Corey Weber. Also, we must give special thanks to our section coordinators, John Buelter and Nicole Peeler, and to the chairs of our BLS Lunch Planning Committee, Paul Pascuzzi and Rob Harris, and a special shout out to Alyssa Miller for planning this event. We encourage anyone interested in joining BLS to do so. We've been so pleased this year to support colleagues who were promoted, lateraled into new positions, created their own firms, and even were appointed to the bench. Speaking of promotions, this is where I get to introduce next year's BLS chair, Everett Green. Everett is an attorney. Speaking of promotions, this is where I get to introduce next year's BLS chair, Everett Green. Everett is an attorney with the U.S. Department of Justice. I have had the pleasure of working with Everett for the entirety of my term on the executive committee and have full confidence in his leadership. Welcome, Everett.
Well, thank you, Soyun. Good afternoon. My name is Everett L. Green, and I also have the privilege of serving as incoming chair of the Business Law section. As Soyun mentioned, the Business Law section is one of the largest volunteer groups of attorneys in the state of California. Our influence, however, is not measured by the number of our members. It's measured by our commitment. We are committed to learning our practice areas that are specialized and that require specialized expertise and learning. And we're focused on providing that expertise to our clients, to the public, to the judiciary, and to the California State Legislature. We're committed to serving the public. We're committed to helping our communities. We're committed to diversifying the practice of law. We're committed to making sure that attorneys focus on their health and wellness. And we hope to we hope to continue many of the efforts that Soyun mentioned in the next year. So please join us and help enrich the practice of law. And finally, I'd like to thank Mark Moore for all of his achievements, accomplishments, both as a practitioner, as an attorney, and also as a very good person. Thank you.
Thanks, Everett. Okay, so I'm so pleased to make two announcements. Number one is we are going to be hosting a live Q&A following the presentation. So please be sure to join us at the conclusion of this program. That also, we're going to be enabling the chat and then also the Q&A function. So during the presentation or any part of this event, you can submit your questions. Okay, and so now we turn over to Paul Pascuzzi. Hi, Paul.
Thank you, Soyun. Welcome everybody to the part of the program where we get to honor one of the greats of California business law with the Business Law Section's Lifetime Achievement Award. And as you heard, this year's award goes to Mark Moore. My name is Paul Pascuzzi. I'm an insolvency lawyer in Sacramento, California, and I have the honor and privilege of being the chair of the Lifetime Achievement Award Selection Committee. The selection committee is made up of all the former chairs of the business law section. And believe me, that's a prestigious group of business lawyers that have high standards for giving this award. The Lifetime Achievement Award is given annually by the business law section to a California lawyer who over an extended period has made significant contributions to the section or to business law generally in the state of California, and who has achieved high status in the legal community. Mark Moore is one of the rare recipients who not only made significant contributions to California business law, but also has made substantial contributions to our very own business law section. And this year is especially fun for me because Mark has been an example to me personally in my business law section career. Mark's work in the consumer financial services area was at the cutting edge of what was a brand new and today very powerful sector of the United States economy. Mark's early work supported banks and other financial service providers as they tried to comply with consumer disclosure and other consumer protection regulations, particularly for their credit and debit card programs. He soon found himself focused on the electronic environments and advocating the view that the electronic signatures in Global National Commerce Act, the e-Sign Act, served as an enabling statute rather than a limiting mandate. Mark's clientele grew to include fintech disruptors in Silicon Valley who faced novel and unexplored 50-state money transmitter and other licensing mandates. Mark's career is filled with experience on first impression legal and business issues. And you can read more about Mark, more than I can cover in my limited time here, in the next issue of the Business Law News. There's a much more thorough write-up about Mark, his background, his accomplishments, and his impressive career. So please watch for that. I think you'll find it interesting as well as inspiring. I can only tease on a few points about Mark's background here, so you know why the selection committee unanimously chose Mark for the Lifetime Achievement Award. Mark was born in Fairfield, California. He's the oldest of 3 children. He has a son and a granddaughter. He's married to his wife, Linda, who's a former Miss Wisconsin. I noticed that when Mark speaks of Linda, his eyes light up as he describes her as his guiding light and source of inspiration. After graduating from the University of California, Irvine, magna cum laude, with a degree in English literature, Mark spent 2 years as a Peace Corps volunteer in the Republic of Korea, where he taught English to South Korean middle school students, among various other positions. Mark went to the University of Chicago School of Law in the early 80s, in the heyday of the introduction of economic theory to the study and understanding of the law. And that likely paved the way for Mark's legal career in business law. Mark returned to Southern California after law school to work for Morrison and Foerster, where he had several mentors you can read about in the Business Law News article. After getting his training at Morrison and Foerster, Mark's travels next took him to the boutique law firm of Aldrich and Bonifant, where he became a partner and then a named partner. Mark served as the firm's president and CEO for 8 years and managed the firm's banking operations practice group for over a decade. In 2014, Mark satisfied a long-held desire to be an in-house counsel for a bank when he went to work for Silicon Valley Bank. In addition to his contributions to business law generally, Mark has made notably substantial contributions to the business law section over several decades of service. Mark served on 3 different business law section standing committees, including chairing the Financial Institutions Committee and the Consumer Financial Services Committee. Mark was the chair of the Business Law Section Executive Committee, the Lifetime Achievement Award Selection Committee, and the Long Range Planning Committee. Mark was also the Business Law Section's representative on the State Bar's Council of State Bar Sections. That was before the sections became part of the California Lawyers Association, and he was elected to co-chair and lead that council. Mark's intellect, experience, expertise, willingness to venture into uncharted territory, innovative approaches, kindness, and humble nature all make him well qualified and deserving of this year's Business Law Section Lifetime Achievement Award. Congratulations, Mark. And on behalf of the Business Law Section, we thank you for all you've done for the business and legal community in the state of California and for the Business Law Section. Mark?
Thank you, Paul, for your kind words. Thanks also to Soyen, who's done an excellent job this year as BLS chair, and to our incoming chair, Everett Green. I never expected to receive such a prestigious award, and I am very grateful. This is a day that I will remember all my life. There are several people I would like to thank by name. Henry Fields, Rick Fisher, and Roland Brandell at the Morrison and Forrester firm set me on a path that offered both challenges and rewards. At the time, I knew I was working with legal superheroes. The only question I had was whether I'd be able to keep up. After leaving Morrison, I went to the Aldrich and Bonifant firm. I still consider them to be the best boutique banking law firm in California. And I'd like to thank the two outstanding lawyers who founded that firm, Mark Aldrich and Janet Bonifant. Finally, I also want to say thanks to my wife, Linda. Roland Brandell once said to me, "Everybody loves Linda." Who am I to disagree with Roland? Now, I'd like to shift a little and share some of my experiences with the State Bar before we had the California Lawyers Association. I began with the Consumer Financial Services Committee and went on to chair another standing committee of financial institutions, also to chair the Business Law Executive Committee and the Council of State Bar Sections. This was all during a time when we were first starting to feel the effects of technology. We wanted a web page and email to electronically communicate with other members. And we hoped to send attractive material to others who might then join BLS or individual standing committees. We brought this up with State Bar staff, and over the years made some progress. But we learned that we needed the sections to advocate strongly and with a unified voice. Even with that, there were impediments and barriers, not all of which were structural or needed, in my view, and in retrospect. Too often we found that bar staff had a sympathetic ear and agreed with our ideas, but were unable to affect change. The example of technology is a good one of how BLS leadership makes such a difference. Our ideas at BLS were sound, and bar staff agreed with the need for improved electronic tools. We led other sections to eventually see they had similar needs. But bar staff also had numerous other things to accomplish and too often seemed distracted or more concerned about their specifics than with ours. We as volunteers often even termed out before real progress was made or projects were changed from front burner to back burner in terms of priorities. In some cases, unfortunately, it seemed clear that staff simply wanted to outweigh us. I think this tension formed one of the basic reasons for disunification and for the creation of CLA. I am glad to be able to tell you that we don't face these problems anymore. From all I've seen, there is much closer alignment between the leadership of the sections and that of CLA. There's also the fact that CLA was built to serve the sections, where the old unitary bar had attorney discipline and public protection as its highest priorities. We are in a better, I would say, a good place now. Technology continues to create new opportunities and questions. In-person meetings of the standing committees have almost ceased over this past year, given the need for social distancing and other COVID-related limitations. We can accomplish so much using video conferencing that we legitimately ask if there's a real need to resume in-person encounters. My thoughts are that standing committees need to meet occasionally and in the same room to build esprit de corps and as a more effective means to identify new leaders. There are habits that come from so much time spent in Zoom, Team, or WebEx meetings, including the temptation to be a passive listener. The stronger chairs can overcome this, for example, by establishing minimum participation standards. But once COVID is sufficiently tamed, I think we will find that in-person meetings are both useful and helpful, even if only occasional. So those are some of my thoughts and reflections about practicing law and being involved with the business law section. I hope that my comments help others to want to join BLS and to aspire to similar activities and successes, since the rewards are great. Let me end by again thanking everybody for this honor and also for your time. Thank you.
Thank you very much, Mark. Very well said. And now I'll turn it over to Rob Harris, who will introduce our panelists for the crypto program. Rob?
Thanks, Paul. Well, I'm Rob Harris, a Silicon Valley bankruptcy attorney and former chair of the BLS. I am pleased to be co-chair of the BLS lunch committee, used to be the breakfast, now the lunch committee with Paul, and I am pleased to introduce our two wonderful speakers for our program, Crypto Assets and Technology, Exploring Legal Issues and Industry Trends. We have Damier Sandrine. She is presently Vice President and Deputy General Counsel at Marqeta, Inc. She leads Marqeta's global product, regulatory, and government affairs functionality. She and her team advise the company on new product development, financial services laws and regulation impacting payments, emerging technology, privacy, banking industry, and government relations. Her experience in technology and financial services spans more than 20 years. Before joining Marqeta, she led the legal practices at Wells Fargo and Silicon Valley Bank, where I believe she met Mark Moore. Damier is a graduate of UC Berkeley and UC Hastings College of Law, and she is a board member of the Financial Technology Association. Eric Weingarten is currently Vice President and General Counsel at TrueWork, a leading digital platform for employment and income verification. Eric has more than 20 years of experience in the field, with the past 10 years spent in-house with a number of the most transformational tech companies in the world. Before joining TrueWork, Eric led the product team at Coinbase, where he supervised attorneys embedded across the Coinbase product suite, including retail, institutional, platform, commerce, and analytics. Before Coinbase, Eric served as Associate General Counsel at Tesla, where he oversaw legal support for consumer finance and consumer energy products. Eric first served in-house as Assistant General Counsel and then Deputy General Counsel for Solar City, after serving multiple tenures as an attorney in private practice at various DC firms practicing in energy project development and finance. So with that, and before I turn it over to the speakers, please stay tuned after the presentation. There will be a live Q&A. You can put your questions into the Q&A box, and our speakers will be back with you live to answer them. So with that, speakers, take it away.
Thank you, Rob. So thank you so much for having us. Eric and I are really excited to be here and to just share with you our thoughts about all that is happening with crypto assets and technology. It's such a hot topic these days. And since you're all lawyers, you'll understand when I say that the views we represent here today are our own. They are not reflections of our employers or any other parties. So with that, I think, Eric, we can jump in and get started. Let's go to the next slide, which is just our overview of what we'll be talking about with you today. We'll run through these 7 areas, and as Rob mentioned, we'll have time for Q&A at the end. So I think we can start off with just level setting on some definitions. You know, we talk about crypto and there are all of these big 50-cent words, and we all mean different things when we're talking about them. So we thought we would just begin by having a few definitions to sort of set the table for our discussion today. So we'll go to the next slide, please. All right, great. So what do we mean by a digital asset? And sometimes this is just referred to as shorthand crypto. A digital asset is, in its simple form, a cryptographic key of numbers. So that means you will not be able to hold it, frame it, touch it, put it in your pocket. It exists on the next term, the blockchain. So what is the blockchain? It's also sometimes referred to as DLT technology or distributed ledger technology. And the blockchain is a software protocol that keeps track and records your digital assets, and it executes transactions. So all of the Bitcoin that you might hold, it exists on the blockchain. If you want to execute a transaction, there could be an instruction sell all of my Litecoin once it reaches a certain amount. That all is executed on the blockchain. The next term that we've heard a lot about lately are stable coins. And a stable coin is a digital asset that is typically backed to a non-digital asset that remains stable. So it's actually pegged to something that is tangible. Recently, you might have heard a lot about USDC or Tether. These are both stable coins that have gotten a lot of publicity lately. And the stable coins really came in to solve the problem of a lot of the volatility and fluctuation of digital assets in terms of their value. So the beauty of a stable coin is you can take that and peg it to, for example, the US dollar, which doesn't have such wide range in fluctuation, hence the term stable coin. The next is a non-fungible token, also referred to as NFTs. These are a type of digital assets that are unique and they're not interchangeable. NFTs also exist on a blockchain. And lately, we've heard a lot about NFTs that are pieces of art, or for example, you could have like the first tweet that ever happened on Twitter and own that, and your rights to that will live on the blockchain. We can move on to the next slide.
Thank you, Damier. I think before we get into sort of the legal constructs, I think it's really important to understand sort of why blockchain, why crypto, why has this all evolved? If you think about sort of business transactions and sort of commerce in general, there's a lot of facilitation in these transactions. Typically, we work through intermediaries to ensure that these transactions are completed, particularly large transactions, transactions of value. And if you think about sort of business law more broadly, certainly in this country and in other common law countries, we rely on intermediaries to facilitate those transactions and ensure that they occur and ensure that you are who you say you are, that you have the money that you say you have, that the good actually arrives. There's all sorts of intermediaries that are built up within our legal structure here that we rely upon. So you can look at things like settlement and confirmation of transactions, just payment transactions. You can think about that in terms of settlement with respect to buying and selling a house with a title company and escrow, or simply buying and selling securities. There's lots of transactions that rely on intermediaries. Those intermediaries are individuals or companies that ensure that all of these things are true. Well, what blockchain really is a replacement for that. And some argue a more efficient and non-discriminating intermediary. And that's sort of the evolution and the birth of blockchain out of frustrations in certain communities, frustrations with those intermediaries. So blockchain and cryptographic proof is very much a mechanism of trust. And a lot of people call it sort of trustless, so that you actually don't need to know your counterparty. You don't need to know the other individual. You don't even need to know that they do or do not have what they say they have, because the blockchain and the proof mechanisms within that will facilitate the actual sort of truth seeking of that. And that's a huge unlock. And if you think about how that could be applied and the implications for the law, there's lots of laws and lots of paradigms that we currently rely on, whether it's thinking about money transmission, or you think about the exchange of securities or commodities that rely on a lot of these intermediaries that, if facilitated in a trustless way that accommodates for those transactions, maybe you can do things in a more efficient way. Maybe you can do those things in a less discriminating way. You can do those things maybe in a fairer way. Maybe you can do those things in a way that provides more access and equity for individuals to the financial system. So a lot of that is the underpinning of what this technology is. That's the construct and the context. And I think that's a really important backdrop when you start thinking about how this concept, this technology fits in with the law as it is today, maybe the gaps that are within the law. And I think you're seeing that right now. A lot of the discussion, whether it's in Washington or in business circles, about how the law should apply fundamentally goes to this issue. You can go to the next slide. Thank you. So just pragmatically, how are people using crypto? What's going on out there? There's a number of sort of core primitives here, whether they be spending crypto, lending crypto or borrowing it, investing in certain activities, or owning. Just wanted to give you a flavor here. So when we go into some of sort of the legal implications, that you have these in your mind, and I think they help as a mental model. I think we're all relatively familiar with the investing construct. That's sort of going long or short on particular assets and their relative value or utility. So that could be buying and selling Bitcoin or any of these other assets. Payments is a very important use case. Damier spoke about USDC and other stable coins. There is a lot of work in and around facilitation of faster payments, payments that can happen instantaneously, large payments. So that's a use case. Borrowing, people are borrowing crypto to do certain things. They could be borrowing things like USDC. They could be borrowing Ether or ETH to be able to use that ETH to perform certain transactions on the blockchain. They could be borrowing traditional fiat to be able to buy more crypto. You could be earning interest on your crypto, and there's lots of different ways that occurs, and we'll talk about that in a little bit. You could receive your compensation, your salary, or payment as crypto in all sorts of different types of assets. Assets are often used to govern the blockchains that they exist on, so that by holding a particular asset, you can vote or propose proposals on how those networks operate. Everything from the number of nodes to the number of individuals participating that need to confirm a transaction is true, to an interest rate that may be paid as a inflationary mechanism on a particular protocol. Assets are used as NFTs in art and gaming. We talked about the title use case, and then these assets can be securities. They absolutely can be securities, and folks are willingly creating securities, tokenized securities, so that all equity is on the blockchain. And that certainly goes directly towards the discussion about whether an intermediary is necessary to be able to settle those transactions. You go to the next slide. So what does this all mean? So this is kind of the setup as we go into looking at the law. There's really three main categories of use, and these three main categories of use are really important when you think about how the law may or may not apply, whether the law exists today or it may exist in the future. These three categories are as follows. One is crypto could be just a means of payment, a store of value. Now that value may go up or down, but ultimately it's really just used as a means of payment. The obvious example here is Bitcoin. I think a number of you have probably heard of ETH or Ether. That can be used as a store of value or a means of payment, but it also has another use, and we'll talk about that in a bit, or stable coins like USDC or Tether. There's another category, which is a digital representation of another asset. The obvious example here is a security, where you hold something, but that represents something else. So it could be security tokens, but it also could be something like NFTs, something where you are holding a digital asset that represents title to a house or fractional ownership in something, such as art. And then the final category, and this is the biggest category, and this is the one that is probably the most disputed and probably the most contentious in the community, in the field, is consumptive use. A number of projects and a number of crypto assets espouse that they can be used in and of themselves for some sort of value intrinsic in the asset. Something like that might be Ether, where you can use an asset to get VPN access, for example, or you can use an asset to participate in a protocol. But ultimately, this consumptive use, this utility, portends that the asset is a commodity as opposed to something that is a digital representation of something else, which might be a security. So we can move to the next slide.
So, why does it matter, like how people are using it? And Eric just walked us through those three categories. And it matters because you have to define what your digital asset is, and that will determine the type of law or regulation that's going to apply. And I think that we're seeing a lot of regulatory uncertainty and a lot of laws and regulations that are seen to cover these digital assets. And it can be a real challenge for innovative companies who want to be regulated, but there's no clear regulatory landscape. So some of the challenges are that depending upon the digital asset that you have and how it's being used, there are a myriad of regulators that, we're showing on the screen here. It's really the alphabet soup that have asserted some type of jurisdiction over your activity. And generally speaking, when we think about the legal or regulatory landscape and what has emerged most prominently, we can look to 4 categories: money transmission, securities, commodities, or banking and lending. And depending upon where your digital asset falls within those categories, that will determine who your regulator is going to be, what laws, will cover your activity, what your licensing requirements will be. And I should also add that you might have multiple regulators depending upon what the digital asset is meant to do. I think that really what we're going to be seeing over the next, I would say 24 months, I'm hoping, is for more regulatory clarity. We started talking about Bitcoin in a meaningful way, I would say almost 10 years ago. And I don't think any of us really could have predicted all of the innovations that have come forward on digital assets. And it's happened so quickly, which is why I think that we're really in this area where we are struggling to figure out how should these things be regulated and who should really be the arbiter. So let's get into the first main category, which is money transmission. And we can go to the next slide, please. So if you have a digital asset and that is being used as a store of value or to move the value between parties, most definitely, FinCEN has already come out with the view that you're engaged in money transmission if it is what they deem a convertible virtual currency or a CBC. So if you are coming within the purview of money transmission, you will need to register as a money service business with FinCEN. You may also need to apply for money transmission licenses in a number of states. One example is, PayPal. You can purchase a cryptocurrency. Coinbase, the same thing. When you are moving value between parties, you are taking, custody of that value. That is definitely seen as money transmission. Why this gets tricky, however, especially at the state level, is that money transmission, as many of you know, it is not treated in any type of uniform way amongst the states that do require licenses for money transmission. Some of those states, New York most prominently, have a specific BIT license, and you also need a money transmission license. There are other states where they define the activity specifically to include digital assets, or they might say virtual currency. And other states are completely silent. So it really is going to be an exercise in determining, whatever your business plan may be, what type of survey you need to do amongst the 50 states to see how you have to be licensed. Just by being a money service business that is required to register with FinCEN, you will have to have, an AML program. FinCEN, the federal regulators, they are concerned with anti-money laundering. The states, more so concerned with consumer protection. And then also, under the federal regime, we have Ofac And definitely, you're going to have to make sure that you have a robust sanctions screening program if you are engaged in, a digital asset that can be used to transfer value between parties. I think we can go to the next slide.
Thank you.
Yeah.
The next will be securities, and we'll get into commodities, which is a bit of sort of a flip side of this. But I think the core question here is, what is a security and why does it matter? I mean, I appreciate amongst our membership here, we probably have a number of folks that, understand the sort of the core definition of what is a security. I'll focus a little bit more on the why does it matter. It matters because of the focus of the laws around securities and ensuring protection for the individual investor. And I think that if you look at the way that the SEC and other securities regulators, not just in the United States, but outside the United States, have looked at crypto and digital assets, I think that they are interested and concerned, and for good reason, about how individuals are utilizing these assets in terms of utilizing them to raise capital or to create, possibly an investment relationship. The conundrum here is that some assets can start out in a way that by definition may look like a security, or certainly under the various tests that are available might be defined as a security, but over time may get distributed enough in a way where no one individual controls them, that sort of the quintessential tests under Howie and otherwise, which we'll get into in a second, don't end up being triggered such that the asset is no longer a security. And this is something that the SEC has kind of indicated, which makes it that much more challenging as a practitioner to be able to understand what an asset is and is not, because at certain points in time, they could change depending on the utility of that asset. So it matters because of that. It matters because, ultimately, if you think about what these assets and a number of them are trying to do, they're trying to create almost an automated sort of financial layer to the internet that isn't controlled by any particular individual, but sometimes it takes a number of individuals in a concerted way and an effort, collective effort, to be able to stand that up as internet protocols were back 25, 30 years ago. So I think it's a good background and a backdrop to be thinking about when you think about securities. The other reason here is that, and this is just more tactical and technical, is that if you are dealing with assets that are defined as securities and you're facilitating the exchange of those assets, you could find yourself in a situation where you are participating in broker-dealer activities on an unlicensed basis. And that's why it's really important to understand whether an asset is or is not a security. There isn't a lot of guidance yet by the SEC or others on this. There are a number of efforts by the industry. Coinbase and others have participated in coming up with scoring mechanisms that follow the Howie Test and potentially the Reeves Test to score assets to determine whether they are securities or not. But ultimately, there is just a lot of uncertainty in this area. We hope to get more certainty over the coming years. The law is quickly evolving here, and that's why it makes it challenging. But just talking a little bit about the Howie test, there's 4 particular elements, and it's really interesting how they do get applied when looking at digital assets and whether these 4 core elements of whether an asset is a security or not get triggered. The 4, many of you are probably familiar. 1 is that there's an investment of money by an individual. That 2, there's an expectation of profits from that investment. And 3, there's a common enterprise. There's a pooling of sorts where that money or those funds get pooled together and then are used to do something, to create something. And this is probably one of the most important aspects, the 4th prong, which is that profit or the investment and the earnings from that investment come from the efforts of a promoter or a third party. That's why there's a lot of focus on these assets on how the value is driven by a core group of founders or facilitators, or if it ultimately is something like Bitcoin, where there is no one individual person that is driving that network. It is completely decentralized. There is no individual that in and of themselves can control that network. And then these are very much the hallmarks of whether something is or is not a security. One final note on this is the Reeves Test. The Reeves Test is specific to a particular type of security for notes, for promissory notes, for lending. A note is by default under the case law determined to be a security unless it is enumerated over time as specifically identified in the case law as not being a security, or otherwise sort of has the hallmarks of the things that have otherwise been enumerated. And it's really important here because there are a number of assets where individuals, for example, will put their money into or put their funds into a network, get back another asset that gives them the ability to get their assets back with a return. And the question then becomes is that asset that they get back a note? Is that asset that they get back a security? And the question then becomes, do they have the hallmarks of all these other things in terms of whether they're expecting profit, which they typically are, but whether they're expecting the efforts of a specific individual or promoter or other party to create that. Does this thing function like something that looks like a security? The law is very limited around that today with respect to how these assets are adjudicated, but ultimately this will be an area of a lot of development because there are a number of products and services that are evolving right now around providing people returns based on the crypto assets that they hold. We move on to the next slide. So if something isn't a security, then oftentimes it ultimately is a commodity. So what is a commodity and why does it matter? Well, it's a fungible asset, something that could exist in the real world, like an agricultural commodity. That's the classic commodity, like corn or pork bellies or something of that nature. But it also could be an intangible, like electricity. And why does it matter? Well, transactions in commodities are highly regulated, again, to protect consumers and investors more broadly. This is adjudicated and governed by the Commodity Futures Trading Commission in the United States. They have broad jurisdiction. And I think, to be clear, they have jurisdiction over not just sort of futures and swaps and derivative transactions in these assets, but also in the markets that participate with commodities. And that's very important because they have anti-fraud and anti-market manipulation authority. And this is where we see the CFTC likely getting very, very active. The CFTC has indicated that Bitcoin and Ether are commodities, and they recognize that as such. And then the implications, well, the implications are that futures contracts in these assets, the contract for future delivery of that asset, must be done pursuant to licensed parties and exchanges. And where this really gets acutely difficult is where you're lending somebody effectively margin to be able to purchase crypto assets and how that should or should not be regulated. And the CFTC has made it very clear thus far that it's very, very difficult to have any sort of lending product around cryptographic assets, a digital asset, without that being a transaction that is governed by the Commodities Exchange Act. And furthermore, something that needs to be done on a licensed exchange that they oversee. Why? Because they want to protect consumers and investors more broadly. We can move on to the next slide. The final category, and this is the one I think is just emerging now, and when people think crypto, money transmission was sort of the first area of the law that it touched, and you saw even back in like 2012 and 2013, the first entities that were facilitating crypto transactions, that's where they started. With the ICO boom, the new assets that were created beyond Bitcoin and Ether in 2017, we started to see the interface with the securities laws. Beyond that, when you started to see some of the derivative type transactions, then you started to see the interface with the commodities laws. And now you're starting to see these banking and lending primitives that are evolving within the space where people say, hey, these cryptographic assets, these digital assets, they're valuable. I want to bank with them. I want to earn interest. I want to save these assets. I want to lend. I want to borrow. That obviously implicates the banking and lending laws in the United States. So there's a host of these, and a number of you may be familiar with them. At the federal level, the OCC, at the state level, there's state banking laws, lending laws, and licenses. There's a lot of overlap here, and a lot of uncertainty, quite frankly, whether these types of deposit taking or lending or savings or interest type of activities are regulated by these laws. Yet to be determined, regardless of whether they are covered under federal banking law or state banking law, whether these things are ultimately in or outside those boxes, which will be determined over time, they still are subject to more generic sort of consumer financial protection laws like UDAP that prevent unfair, deceptive, and abusive acts and practices under Dodd-Frank or the similar state corollaries. And I think this is an area that folks aren't focusing on as much, again, particularly because banking and lending law is just emerging as an interface for oversight. But furthermore, that folks aren't thinking about how these products and services may or may not be confusing to customers. And it very well may be that the state AGs get very active in this space as consumers may or may not understand these lending products. They may or may not understand the risk and believe that the product or service that they're getting is, oh, well, this feels like a savings account. And the offeror wasn't clear about that it wasn't subject to whatever the applicable law is, and that this may be a cause of action. So I think that's another area of interest and another area that folks need to be thinking about as they're developing products in these spaces. You can move to the next slide.
So thanks, Eric, for laying that out. I think what we know, we talked a lot about, there are all of these emerging use cases, a lot of innovation, and law and regulation has not kept up, and we're still struggling with a fair amount of ambiguity. I just want to highlight here on this slide, there is both existing and proposed legislation. So if you're either working, for a company that is very active in digital assets, or your client is innovating in this area, there are a couple of, I would say, critical pieces for you to take a look at. So the FinCEN guidance on convertible virtual currencies, that is already existing, and as I mentioned before, FinCEN has already been very clear that anytime you are dealing with a convertible virtual currency, that is going to be subject to their jurisdiction. Ofac has come out with a framework for compliance and FAQs on virtual currency. And as we'll see on the next slide, when we look at some of the enforcement action that has happened, it would really do companies well to take a look at this guidance that's been published. FinCEN has some forthcoming rules and proposals over, actually, I just think about this fondly. It's something that Mark and I talked a lot about when we worked together previously, the travel rule and the record keeping rule. There has been some proposal on, reducing the threshold amount for when those covered transfers are going to be implicated. I think the proposals has come down from $3,000 to $250, and it's still, I think there is still either out for public comment, or they have paused rolling out this rule because it has been controversial and complicated, especially the aspect of it that talks about CVC for quote unquote unhosted wallets. And the travel rule and record keeping rule is all about sending information with a transfer of funds. And sometimes when you're talking about a transaction that involves a digital asset, the amount of information that you may have to send with the transfer, it could be limited. And it's, also could be masked by the cryptography. So it's going to be a challenge, to comply with rules as they are proposed and presently written. There's another proposed legislation, this Digital Asset Market Structure and Investor Protection Act. That was proposed in July, and that proposed bill would actually seek to bring some clarity and pretty much state that digital assets are securities and they should be regulated by the SEC. And I think that this is a lawmaker in Virginia who has proposed this. And we'll see, if that gets any traction. There's also the Stable Act, and that was specifically introduced to regulate stable coins. And I think lately, especially with Janet Yellen making comments around stablecoin, and there's been a lot of discussion and movement around USDC, which is the stable coin that is pegged to the US dollar. We've seen a lot of commentary from monetary policy experts about stable coins and how they should be regulated and explaining how they operate. But this is the legislation that was proposed at the end of last year, but it still has not moved yet in Congress. And then also FATF, which is the Financial Action Task Force, is a global organization with many countries that participate to develop policy and compliance frameworks. They are currently updating their guidance for what's called a VASP, which is a virtual asset service provider. And I think the theory there is, as a global community, these are digital assets that literally move around the globe. What are some common standards? How should we be thinking about country by country, how to take a look at these for AML purposes, for consumer protection? How should they be regulated? And then finally, with respect to the current infrastructure bill that is playing out in Congress now, I think it's a $3.5 trillion bill. And one of the pay-fors is to look to find $28 billion in revenue from imposing taxes on crypto. So that's some existing movement in terms of new and proposed legislation. And we can go to the next slide to talk a little bit about enforcement. Here, I just wanted to highlight some notable enforcement activity. And this is all very recent, all occurring within the past year or two. Both FinCEN and the CFTC imposed a pretty substantial penalty on BitMEX for AML failures, specifically not flagging that they had Iranian participants on their exchange, not having appropriate AML oversight or compliance. And so they were required not only to pay this money, but also to absolutely up-level their compliance program and hire someone to manage compliance there. They were accused of doing things like setting up an entity in Seychelles to specifically circumvent, AML limitations. Then also the SEC has brought an action against Ripple, alleging essentially that XRP is a security and they're offering up XRP as an unregistered security offering. The same type of thing with Telegram. The SEC settled with Telegram, and I would say a lot of the money that was raised by Telegram, they had to return $1.2 billion and incur an $18 million penalty because they saw that as, an unregistered security offering. And Eric, mentioned this previously, ICOs, which were initial coin offerings. And that was, the 2017 heyday. And we saw a lot of companies try to raise capital in this way. And ultimately, the SEC has made it pretty clear that an ICO isn't essentially an unregistered security offering. And if you want to raise capital that way, you will need to have a registered offering or have a recognized exemption from that. I would also call out the Ofac settlement with Bitpay, and this is related to sanctions violations. And I thought what was interesting there is that the Ofac, as we mentioned on the prior slide, they have a compliance guide. And when you are looking at the types of entities that are on your platform, there's an expectation that you do things like look at the IP addresses. And if you can see that a user is coming from an IP address in a sanctioned region, or if you are collecting any type of information that suggests that they are resident in either a comprehensively sanctioned or partially sanctioned territory, you need to be doing some more screening for Ofac purposes. And then finally, and very recently, this week, I believe, the SEC sent a Wells notice to Coinbase, which essentially threatens to sue Coinbase if they come out with their lending product, because the SEC sees that as a security. So all this to say that, there is no lack of regulation here, and this activity with respect to how digital assets are being utilized, it's just getting so much attention with lawmakers and regulators. And any type of activity that your companies are engaging in, you really want to take a look to define what is the activity. You need to be able to explain the product, and it would do you well to decide what the product is and what the regulatory landscape is where you feel like it fits, rather than having a regulator tell you otherwise. So I think at this point, we're at the end of our presentation, and we will have time for Q&A.
Well, thank you so much, Damier and Eric, for getting us through these emerging issues. This topic cuts across so many different practice areas and industries that we're really looking forward to hearing the audience questions during our Q&A session. But before we move everybody into that room, we wanted to thank Beth Pierce for helping us produce today's event. And then also, of course, on behalf of BLS, thanks to everyone who's attending and participated in our BLS annual lunch. We wish you the best in wellness and health. And of course, after you attend the Q&A, enjoy the rest of the CLA annual meeting. Thank you, everybody.